Seizure of assets overseas. Can Energy has reportedly won a French court order authorizing freezing of Indian properties in Paris. Why is Can going after Indian assets? Are there any such precedents? What are Indian options? Britain's Can Energy has secured an order from a French court authorizing the freezing of 20 Indian government properties in Paris valued at over 20 million euros. The London based Financial Times reported Thursday. This is the first court order secured against India to enforce a $1.2 billion arbitration award that Can Energy had won against the Indian government in the retrospective tax dispute. On Thursday, the Finance Ministry said it had not received any communication in this regard from any French court and that it was trying to ascertain the facts. What is the dispute about? The arbitration between India and Can challenged the Indian retrospective taxation policy. In 2012, India brought in legislation mandating retrospective tax demands over deals going back to 1962 in which shares in non-Indian companies were transferred to an Indian holding company. In 2006, Can made a bid to consolidate its Indian assets under a holding company, Can India Limited. In doing so, Can UK transferred shares of Can India Holding to Can India Limited, essentially transferring shares in non-Indian companies to an Indian holding company. Later, when Can India divested roughly 30% of its shares through an initial public offering, mining conglomerates Vedanta Pictures acquired most of Can Energy, but Can UK was not allowed to transfer its 9.8% stake in Can India to Vedanta. Indian tax officials said that capital gains tax of rupees 6,000 crore is payable by Can UK for the transaction in 2006, even though the transaction had previously been cleared by them. In fact, the Supreme Court had ruled against the retrospective reading of the law by tax officials in the case of Vodafone. However, Parliament passed the law mandating retrospective taxation over transfer of Indian assets. This retrospective taxation, Can argued, was in breach of the UK-India bilateral investment treaty, which had a standard clause that obligated India to treat investment from UK in a fair and equitable manner. Why is Can going after Indian assets? In December last year, a three-member International Arbitration Tribunal ruled unanimously the Indian government was in breach of the guarantee of fair and equitable treatment and against in India-UK bilateral investment treaty, and that the breach caused a loss to the British Energy Company and ordered compensation of 1.2 billion. The Indian government is yet to accept the arbitration award. Can Energy is going after Indian assets overseas to recover the compensation. In May, Can began the process of extracting 1.2 billion. Why has India not accepted the award? Since the arbitration award was delivered in Hague, India has moved an appeal in the Netherlands. A similar arbitration verdict was delivered in September last year in favor of Dutch telecom company Vodafone. The award requires India to pay $5.47 million to Vodafone as partial compensation. What are the assets Can is going after? Can Energy has so far registered the arbitration award in several countries where it has identified Indian assets worth 70 billion. This includes jurisdictions in the US, UK, Canada and Singapore, Mauritius, France and Netherlands. In the US, Can Energy has chosen New York to sue India because it has located substantial assets it can recover the compensation in that jurisdiction. Specifically, Air India's United States operations are headquartered in the district at 570 Lexington Avenue, New York 10022. According to the Financial Times report, the French court tribunal Judiciaire de Paris on June 11 agreed to Can's application to freeze residential real estate owned by the Government of India and Central Paris, particularly in the 16th arrondissement of Paris, a marquee neighborhood in which a residential property, according to the newspaper, has served as the residence of the Deputy Chief of Mission at the Indian Embassy. What are India's opting forward? While it is first one to succeed, Can the French court ordered boosts in chances in other jurisdictions. The assets will be tangled in legal dispute and India will join a list of countries that include Pakistan, Afghanistan, whose assets were seized abroad. Unless it can be proved that the arbitration awards against India are nullified in the appeals, the award can be enforced in foreign jurisdictions. However, settlement between the two parties cannot be ruled out. Is there any Indian precedent for such seizure of property belonging to foreign states? Seeking court's intervention, enforcement of arbitration awards against the foreign states is fairly common. Last month, a case filed by two Indian private companies for enforcement of arbitral awards in their favor, the Delhi High Court directed the embassies of Afghanistan and Ethiopia to file affidavits disclosing the assets owned and held by them in India. While KLA Cons Technology sought to recover approximately 1.72 crore from the Islamic Republic of Afghanistan, is enforced by an arbitration award in which the Supreme Court had appointed sole arbitrator. The other Indian firm Matrix Global Private Limited sought to recover 7.60 crore from Ethiopia. The ruling Justice J.R. Midha was looking into the question of whether a foreign state can claim sovereign immunity against enforcement of arbitral award arising out of a commercial transaction. Thank you.